From Capitol Hill to the Supreme Court, where Chief Justice John Roberts announced the last rulings of the term will be issued on Monday. Today, the justices released 3 decisions. The biggest judgment came in Fischer versus the United States. A 6-3 conservative majority ruled that January 6th rioters could not be prosecuted under a rare financial record-keeping law that criminalizes destroying evidence and obstructing an official proceeding. For more, let's go to Rick Garnett, professor of law and director of the Notre Dame Program on Church, State, and Society. He also clerked for former Supreme Court Justice William Rehnquist. Rick, great to see you again. Thanks for coming on. First off, let's start with a case involving January 6th. Your reaction and what it means for those charged under the provision.
Yeah, really quick thing. An interesting thing about this case is that it wasn't 6-3 with the conservatives against the liberals. Justice Amy Barrett dissented in this case, and Justice Ketanji Brown Jackson was in the majority. So there was a kind of partisan disagreement here. This is a case about how to interpret a federal obstruction of justice statute, and it was really in the weeds lawyering by the justices, the Chief Justice on one side for the majority and Justice Barrett on the other. And it was just, like I said, just really good, interesting lawyering. I'm going to use the case in my criminal law class next semester. In terms of what it means for the folks with January 6th convictions, the reality is not much. Almost all of the people who were convicted of multiple charges under multiple statutes. So a whole lot of people are going to have to be resentenced, but it's very unlikely that very many people will either have their sentences eliminated entirely, or that they'll get, those people who have been sentenced to jail time, prison time, that they'll get substantially less time. So it's an interesting technical case, but it's actually not going to make much difference to them, and it probably won't make much difference itself to the case that Mr. Smith has going against former President Trump.
Yeah, and I was going to ask about that because 2 of the 4 charges against former President Trump in his January 6th indictment involve this obstruction law. So can we maybe talk about that a little bit more?
Yeah, well, so the wrinkle is this particular statute, it was enacted after the Enron scandals. And the disagreement among the justices was whether it's limited to cases where a person is alleged to have interfered with an official proceeding in a particular way, namely by tampering with evidence, with shredding documents, that kind of stuff, because that had happened after the Enron problems. A lot, obviously these people in January 6th who were storming the Capitol, for the most part, they weren't doing anything like that. So the court said, you stretch the statute too far to use it against those people. In President Trump's case, it's at least alleged, we'll see what happens in terms of proving, but it's at least alleged that he was involved in some efforts perhaps to mess with some documentation, right? Some of the official forms that you would need to do the electoral count. So even on the court's new interpretation, in theory, President Trump's alleged conduct might come under that.
We have about a minute left or so, but I also want to get to this one, another big one, a 6-3 ruling in the Loper Bright Enterprises versus Raimondo. In this case, the court greatly curtailed federal agencies' powers. Tell us more about that and what this ruling now means for small businesses.
Yeah, this is a really interesting and important case. Basically, it has to do with when we have a regulation that an agency has created, and there's some kind of legal challenge about the meaning of that regulation. Should the court defer to the agency, or should the court exercise its own independent judgment? And obviously, if the rule is courts should defer, that gives the agencies a lot more power. And that's what this Chevron rule had decreed, that generally speaking, courts should defer to the agencies when they're enacting regulations on matters that are within their purview. And what the court said today, and again, this is very important, is that the structure of administrative law in the United States requires judges to make legal determinations on their own and not to sort of outsource that decision-making to the administrative agencies. So you asked about small business. I mean, small businesses, like so many other parts of our lives, are pervasively regulated. And what this means is just that folks can be sure that questions about the meaning of federal law are going to be decided by judges rather than by administrators.
All right, we're going to leave it there. Great to be with you. Thanks so much for your insights. Appreciate it.
My pleasure.